Do you think we're ready, Joe, or a few more minutes?
Arabella, we can start if you like. Yep.
Okay. Good afternoon, everyone. I'm Arabella, and I'm the newest tenant at Five Stone Buildings. Before we begin, I should say that if you want to ask a question, please use the Q&A box feature. Hopefully there'll be some time at the end for me to answer a few. The webinar is being recorded, so if you don't want to be identified when asking the question, make sure you tick the anonymous box when you ask it. When I planned this webinar, I had in mind trainees and NQs who are starting out in the area, but everyone's very welcome. It can be really helpful to refresh the basics and think about the bigger picture. As a kind of general overview, I'm going to be mapping out the sorts of claims you typically come across in this really fascinating area of the law. We only have half an hour, so it will be a bit of a whistle-stop tour, but several of my colleagues in chambers have recorded webinars focusing on just a few of these areas and covering them in more depth, and those are up on the Five Stone Buildings website and YouTube account. So when most people say contentious probate, they essentially mean contesting a will. But in practice, when you work in this area, you see not just challenges to the validity of the will itself, but also other sorts of claims that don't strictly fall under the definition of probate. But if they're successfully pleaded, they can end up effectively undermining the provisions of a will anyway. They can also affect the distribution of the deceased's estate when there isn't a will in the mix and the deceased died intestate without leaving a will. I've divided the sorts of claims you might commonly encounter into three broad categories. If we could please go to the first slide, Joe. A will has got to be valid both in its form and in its substance, so we'll look at challenges to both of those. And then we'll also take a really quick look at some of the ways in which someone might be able to undermine the devolution of an estate under a will or an intestacy without actually attacking the will itself. So, starting with formal validity, could we move to the next slide, please, Joe? We're starting with statutory requirements. In brief, for a will to be valid in form, it has to comply with Section 9 of the Wills Act 1837. It's relatively rare to get a case that turns on this. If you do, it's most likely to involve a DIY will rather than one that's been professionally prepared. Broadly, a will isn't valid unless it's in writing, signed by the testator, or signed by someone there with the testator whom he directs to sign on his behalf. And the signing's got to take place in the presence of at least two witnesses who each signed the will to verify that it was properly signed by the testator. Those witnesses also have to sign in the presence of the testator. So as you can see, everyone has to be together when the will is executed. Obviously, that's been difficult since the outbreak of the pandemic this year. With that in mind, an amendment to the Wills Act came into force at the end of September this year. It's up on the slide. The only change it makes to the formalities is to allow for the witnesses to witness the signing remotely via a video link. It's a retroactive and a temporary change. It will apply to wills made between the 31st of January 2020 and the 31st of January 2022. The reason why you can't necessarily just have family members or people in your bubble do the witnessing is that those people are likely to be the beneficiaries under the will that's being witnessed. If a beneficiary, or importantly, a beneficiary's spouse or civil partner is a witness, that beneficiary will forfeit their entitlement to whatever they were supposed to get under the will. But crucially, the fact that a beneficiary has witnessed the will won't invalidate the will. That in itself can sometimes be quite devastating. I recently encountered a case where the testator had one estranged sibling, they did not like each other, no other relatives, and he wanted to leave his entire estate to two very close friends who had treated him like family for years. He had already made a will that left those friends half of his estate, but he decided that he wanted to make a new one, leaving them the whole thing. He unfortunately wasn't that well advised, and both of those friends were the witnesses to the new will. If that had invalidated the new will, things would have bounced back to the previous will, and the friends would have at least got half of the estate. But because the witnessing didn't stop the final will from being valid, that will validly revoked the previous will, but the residuary gift to the friends failed because they had to forfeit it, and the entire residuary estate passed under the intestacy rules to that estranged sibling. Could we have the next slide, please, Jay? Could we move on to the next? Oh, great, thanks. Forgery. I've put forgery into the formal validity category just to space things out, but it affects both the formal and the substantial validity of the will. Forgery is a form of fraud, so it needs to be specifically pleaded, and you should have compelling evidence before you allege it. It's not a criminal standard of proof, but it's a high civil standard of proof. You might be looking at forgery of the signatures on the will, or even a situation where someone's tried to superimpose different terms of the will onto a document that already bears the genuine signature of the testator. You'll be getting a handwriting expert in. You can also look at the ink that was used and get equipment to examine the document, which can reveal whether impressions of writing on other pages that were on top of the document have been left, and so on. Could we go to the next slide, please, Joe? We're now on to substantial validity and challenges to that. We're starting with lack of testamentary capacity. Essentially, the law doesn't see you as capable of making a valid will if you're not of sound mind, memory, and understanding. Your mind doesn't have to be perfectly sharp, but there's a threshold. The legal test for testamentary capacity is still one that was set out in a case from 1870 called Banks and Goodfellow. I've put it on the side. It basically says that for a will to be valid, the testator must understand the nature and effect of what he's doing by making a will. He must understand the extent of the property he's disposing of under the will. He's got to be able to recall the people who he ought to consider as his possible beneficiaries. And he must not suffer from any insane delusions which influence him to do something in his will that he wouldn't have done otherwise. As you can see, there's some quite Victorian language in the test, and lots of people have pointed out that it's pretty outdated in the way that it approaches mental health and the mental faculties. There have been some noises about whether the Banks and Goodfellow test has been affected or superseded by the far more recent Mental Capacity Act 2005, but at the moment, the courts still appear to be sticking to it. Lack of capacity is one of the most common challenges to a will, maybe inevitably as people tend to start thinking about making a will or making changes to a will when they're more advanced in age, and there might be some questions about their capacity at the time they executed the will. It's quite often the case that at an advanced time in their life, they might be in and out of hospital or seeing a doctor regularly, and if their capacity is called into question after their death, their medical records often become hugely important, and you get very familiar as a lawyer with the way that doctors write their notes and with all of the mental capacity tests that they do in hospital, what's a good score on that test, what's a more worrying score, and so on. There's a case from this year called Clitheroe and Bond. I've put it on the side. It focuses on insane delusions in the lack of capacity test. It's legally a very interesting case, but the facts are also really engaging. It's not often that an important aspect of a probate case is the allegation that one party stole 65 small trolls. There's also an allegation about the theft of a Swarovski crystal collection, which I personally found notable because I think it's the third case this year that I've come across where people are fighting about Swarovski crystal collections. They're clearly having a moment right now. Anyway, I won't go too much into Clitheroe and Bond because Hugh, my colleague in Chambers, has recorded a webinar about it, which is up on YouTube. But I found it very interesting because the deputy master in that case appears, I think, to equate an insane delusion with a belief that's objectively false, which I'm not sure about, because people often say things about their family members that perhaps are unfair opinions or comments that arise out of a misunderstanding or hurt feelings. And a fully informed third party could perhaps, in the cold light of day, with all the facts before them, say, actually, no, that's false, what you've said. But if that's all that's required for an insane delusion, I think quite a few of us could be said to suffer from that kind of insane delusion from time to time. And I would query whether that alone really negates testamentary capacity under Banks and Goodfellow. But have a read of the judgment for yourself. I think it's worth the time. Could we go to the next slide, please, Jo? Want of knowledge and approval is another ground under which you could overturn a will potentially. As the name suggests, a testator must know what's in his will and what practical effect it will have, and he must approve of it. Where there's a lack of capacity claim, you'll often see a want of knowledge and approval claim thrown in as well. The idea being that even if you can't quite prove lack of capacity, if you have a testator who was maybe quite frail and not fully aware of what was going on, that might be enough for want of knowledge and approval. You also might see it pleaded alongside undue influence in a situation where someone else seems to have taken a suspicious role in organising the will or deciding its provisions. It's worth mentioning presumptions and the burden of proof at this stage, because things can shift around a bit depending on the evidence that comes to light. In ordinary circumstances, you start off with the legal burden of proof being on the person propounding the will. That's the person saying the will is valid. But once proof comes to light that the testator had capacity and duly executed the will, there usually arises a rebuttable presumption that he did know and approve of the contents of the will when he executed it. At this stage, the evidential burden of proof shifts to the person who's opposing the will, and that person will have to rebut the presumption if they want to be successful. If they can rebut the presumption, then the person propounding the will must produce affirmative proof of the testator's knowledge and approval in order to satisfy the legal burden of proof. The standard is still always that of the civil balance of probabilities. If it's not your typical situation and you have a testator who's blind, illiterate, couldn't speak, or has someone else sign the will on his behalf, there's no presumption of knowledge and approval that arises. You always need to show affirmative proof of knowledge and approval if it's questioned. And it's the same if the will is prepared and executed in circumstances that would excite the suspicion of the court. In terms of what proof is sufficient, in general, if a testator has given instructions for the will, has read the will over carefully, or has had it read to him clearly before he executes it, and there's no evidence of any beneficiary playing a part in executing the will, that tends to be sufficient proof of knowledge and approval in most cases. In terms of the circumstances that would excite the suspicion of the court, the classic example is where a person who benefits significantly from the will is also the one who prepares it, or alternatively, is the one who suggests the terms of the will to the testator, sets up the meeting with the solicitor, takes him to the will writing appointments, and so on. You can see how it might be tempting to bring a want of knowledge and approval claim where you have a situation that kind of suggests dishonesty or fraud, but you don't have clear evidence of it. But the court is really alive to that and won't allow want of knowledge and approval to be a kind of Trojan horse claim for allegations of fraud. So the suspicious circumstances alleged really do have to be about the preparation and execution of the will. They can't just be generally suspicious circumstances. Could we have the next slide, please, Jo? Thank you. Undue influence. This is where a testator is basically coerced into making a will that he doesn't want to make. You may have come across undue influence in a scenario where a lifetime gift is set aside because of undue influence. That's undue influence in equity. But we're talking about undue influence in probate. And the crucial thing to remember is that they are not the same. With lifetime gifts in equity, you can have presumed undue influence. When it comes to wills and undue influence in probate, there is no such thing as presumed undue influence. You have to show evidence of actual coercion. So it's not an easy claim, and it's a serious thing to allege. You need really strong evidence. The relative frailty and vulnerability of the testator tends to be highly relevant in these claims, as well as how dependent they are on the person who's been accused of coercing them. The coercion could be actual violence or imprisonment, or it could be persistent pressure, which wears down a really weak and fragile testator to the point where they just give in to it so that it stops. The main thing to remember is that it does have to be coercion. Persuasion or strong advice is not enough, which is quite a significant barrier when you think about it. One sibling might persuade a parent to leave everything to them, and if it's just persuasion on its own, that could be a valid will. Could we move to the next slide, please, Jay? So fraudulent calumny. Finally, in the category of challenges to the substantial validity of the will, I've put in fraudulent calumny. It's basically the Aperol spritz of the contentious probate world. It's been around for a while, used to be a relatively niche choice, and then in the past decade, it's just exploded and now seems to be everywhere. But like an Aperol spritz, it's definitely not for everyone, and I think it's actually one to treat with caution. Fraudulent calumny is often viewed as a branch of undue influence, but it's a separate ground in its own right. With undue influence, think coercion, but with fraudulent calumny, think poison. The idea is that A poisons the testator's mind against B by casting dishonest aspersions on B's character. If the testator then excludes B from his will or hugely cuts down the benefit to B, and B would have been a natural beneficiary for the testator, then that amounts to fraudulent calumny and the will can be set aside on that ground. The classic situation involves two siblings and a parent. And very sadly, an example of a common allegation is sibling A telling the parent that sibling B has been stealing from the parent. As with undue influence and forgery, it's a really serious claim. You can't just allege it left, right, and center. There has to be particularly cogent evidence. It can't just be circumstantial evidence or supposition on its own. Clients are often quite keen to plead fraudulent calumny, but if it's pleaded on really weak evidence, it can lead to serious cost consequences for a party. And in a worst case scenario, if it was really unarguable, it can lead to professional consequences for the lawyers involved. There are also other difficulties to bringing a fraudulent calumny claim. First, the alleged dishonest representation about the person's character does actually have to be shown to be false. Where the representation is really a subjective opinion, it might be difficult to prove that it's false. In a case called Kunicki and Hayward, it was held that there had been a negative statement about someone's character, but the court didn't think that it was necessarily untrue. Second, it's not even enough to show that the statement is false. It's got to have caused the testator to change his will or make certain provisions under his will. There can't be any other explanation for why the testator excluded that particular person from benefit. Third, fraudulent calumny might not catch everything. For example, sibling A repeatedly telling her mother that sibling B was very well off and had no need for an inheritance might persuade the mother to exclude sibling B from her will. Arguably, even if sibling A was making things up, you couldn't bring a fraudulent calumny version on the character of sibling B. I should say that there hasn't actually been a case confirming that yet, but it's something that does seem to fall outside the judicial definition of fraudulent calumny, so it's something to bear in mind. Fourth, there's potentially a cast iron defence open to the party accused of fraudulent calumny. Even if sibling A is found to have made a poisonous representation about sibling B that was false, but caused the parent to exclude sibling B from the will, a fraudulent calumny claim won't succeed if sibling A believed what he said about sibling B. Fraudulent calumny can only exist if sibling A knew that the aspersions he cast on sibling B were false, or he didn't care if they were false or not. In other words, he was reckless as to their truth. This means that sibling A might have spread things to a parent that are really poisonous, unfair, mean-spirited, and completely untrue. But if they represented sibling A's true opinion about sibling B, they won't invalidate the will. So there's a lot of evidence that you need if you're going to bring this claim. Evidence that the testator had a negative belief about someone's character, causing them to exclude that person. Evidence that the other side fed that negative belief to the deceased. And evidence that the other side fed that belief knowing that it was false or not caring either way. And then there's overlap between a lot of these grounds under the substantial validity heading, because in practice, it might be unclear whether a really harsh or strange belief that was expressed by a testator arose from a fraudulent misrepresentation fed to him by another, or the testator's own completely unfair but capacitous opinion, or an insane delusion that indicates a lack of capacity. Could we move on to the next slide, please, Jo? So I've got one eye on the time. We're going to take a very quick look at other ways of undermining a will or the intestacy rules. We're starting with proprietary estoppel. It's a difficult claim to take to trial, but if successfully pleaded, a claimant could be awarded an interest in the testator's land or appropriate compensation, despite the testator not having given the land to the claimant under his will. I imagine everyone's familiar with proprietary estoppel, but just a quick recap. The elements of it are an assurance about an interest in land made to the claimant, reliance on that assurance by the claimant, detriment to the claimant as a result of his or her reasonable reliance, and this general notion that it would be unconscionable for the deceased to go back on his word. The element that very often seems to be a main ground of contention in proprietary estoppel claims is detriment, and the question of what really is sufficient in terms of detriment. How bad a time do you have to have had, and for how long? You'll also be thinking about what countervailing benefits the claimant might have got out of this situation at the same time as any detriment. For example, they might have worked for the deceased for very little pay, but the deceased might have provided a property for them to live in rent-free while they did it. Could we have the next slide, please, Jo? So, 1975 Act claims. Unlike in some other jurisdictions, it's a principle of English law that a person can choose how he leaves his property on his death, even if he makes a choice that many people would think was unwise. Someone in Chambers actually did a case once about a millionaire who left the vast majority of his estate to the Vegetarian Society and not his sister and her children. He not only had no particular affiliation to the Vegetarian Society in his lifetime, but he wasn't even a vegetarian. And all of this evidence was adduced about how much he liked sausages and how much he liked bacon and so on. And it really was a testamentary capacity case, but the court held that the testator just didn't feel the bond of natural love and affection with his family that people usually feel. And he consciously decided to leave his estate elsewhere. And the court decided that the law would uphold and respect that decision. So it's actually quite a significant encroachment on that freedom that we now have the Inheritance Act 1975. The full title is on the side. It's a bit of a mouthful, so people normally say the 1975 Act or the Inheritance Act. It allows certain categories of people to apply for provision or further provision from an estate if they can show that the will or intestacy doesn't make reasonable financial provision for them. The rationale is basically that if you have someone who would naturally be a beneficiary, basically family members or people who are dependent on the deceased, And if that person is really in need of funds and there are funds available in the estate, they should, to the extent that's necessary, be supported by the estate rather than the state having to support that person. Moving on to ways of undermining a will that are slightly less common than proprietary estoppel and 1975 Act claims, but do still crop up from time to time. Could we have the next slide, please, Jo? Thanks. There are these 4 equitable doctrines. I'm not going to go much further than just outlining what these are. If you want to hear about them in more depth, Matthew Roper has recorded a webinar on them called Often Overlooked Doctrines, which is up on the Five Stone Building's website and YouTube. So briefly, donatio mortis causa, it's basically a deathbed gift. It's an exception to the formalities contained in the Wills Act 1837. The gift must be made when the donor is contemplating his imminent death. It's got to be conditional on the donor's death, and the donor must have made a delivery showing his intention to part with dominion over the subject matter of the gift. The classic example is the donor placing the title deeds to a property in someone's hands, or maybe the keys to a car, something like that. The rule against double portions is essentially a historical presumption that a parent will intend equality among his children. So if a parent leaves a child a legacy by will, but then after making that will makes a lifetime gift that's very similar in nature to the legacy, there arises a rebuttable presumption that that lifetime gift has satisfied the legacy that was given under the will, basically that the parent wouldn't have intended to make the same gift twice. This is quite a useful doctrine in a situation where children might have been treated equally under the will, but then one goes on to receive far more financial support from the testator during the testator's lifetime. You do need to make sure that the will and the lifetime gifts fall in the correct order, though, before trying to say that there's a presumption against double portions, so make sure you check that carefully. Secret trusts, where someone leaves property to someone in a will on the understanding that that person will hold the property as trustee for a beneficiary who's not named in the will. I think most people think about mistresses and secret families when they think about secret trusts, as it's hard to think of many other situations where someone might need to keep the identity of their beneficiaries secret. And then the rule in Strong and Bird. You'll only really be thinking about this where your client is the executor or administrator of the deceased estate. In brief, if the deceased made an imperfect lifetime gift, equity will perfect it if the property gifted becomes lawfully vested in the donee because he becomes one of the deceased's personal representatives, and if the deceased has to have manifested an intention right up to his death to make that gift. So that's everything I have in the third category of claims. Could we have the next slide, please, Jo? Thank you. The final point I'll make in general is that the end result in a probate claim can be really quite different depending on the method used to challenge or undermine the will. Successfully challenging the form or substance of a will means that the will won't be admitted to probate. It's effectively cancelled. You'll either revert to a previous will as long as it's valid, or if there's no valid will to fall back on, the intestacy rules take over. In that way, that kind of challenge is quite a blunt instrument and it will often be brought by someone who stands to gain under a previous will or on intestacy. Very often that's adult children. But things like a 1975 Act claim or a proprietary estoppel claim and those equitable doctrines won't invalidate the whole will or stop it from being admitted to probate. In a way, they're a far more specific challenge, even though they could decimate an entire estate. For example, if the property that's subject to a successful proprietary estoppel claim is the only real asset in the estate. Sometimes a client might be confined to bringing these sorts of claims because it's not actually in their interest to have the will declared invalid if they wouldn't benefit under the previous will and they wouldn't benefit under the intestacy rules. So with the exception of the 1975 Act claim, these sorts of claims are often more pinpointed and focused on a particular chattel or property. I know we're already 1 minute over time. I'll just take a quick look at the questions and see if I can answer a few briefly. Can lots of combinations of these claims be brought together? It's very common to have one probate dispute with multiple grounds like lack of capacity, want of knowledge and approval, and undue influence all in the same claim. You could also have undue influence and proprietary estoppel in the same claim, or even one of the doctrines like donatio mortis causa, as long as there's an overlap of evidence and it makes sense for everything to be heard together. The thing that you won't have together is an Inheritance Act claim. So for one thing, probate disputes like lack of capacity, undue influence are all Part 7 claims, but Inheritance Act claims use a Part 8 claim form, so you just don't hear them together. There's also unlikely to be a huge overlap of evidence between the two claims, and you just wouldn't really bring both claims at once when winning just one of them would be enough. It's very common to do things one by one, so to have a probate claim first, and then if you win on that, you don't need an Inheritance Act claim. There is a time limit for bringing an Inheritance Act claim, so sometimes people issue that claim protectively and then stay it pending the outcome of the probate claim. Can you insulate a testator from any of these claims arising over his estate after his death? That's kind of the million-dollar question. It's really hard to make things watertight. If someone lacks capacity, in some circumstances, you can get the court to approve a will for them, and that's known as a statutory will, and that will be the court of protection. And because the court is involved in the execution of that, there realistically isn't going to be a question of a challenge based on lack of capacity, want of knowledge and approval, undue influence, or forgery, fraud, or non-compliance with the formalities, because the court was involved. But there could still be a 1975 Act claim, or maybe even a proprietary estoppel claim, especially if there's quite a lot of time between the execution of the statutory will and the person's death and circumstances have changed. As for ways that you can make a claim less likely, you can't, people do still bring weak claims, but I suppose there are things you can do to really rebuff a claim that's brought. A lot will depend on the will writer and how they choose to handle the client and how thorough their notes are. There's something called the Golden Rule, which is set out in a case called Kenwood and Adams, and it's an obligation on solicitors who are writing a client's will to assess their testamentary capacity, and if there's any doubt about it, or the testator is very elderly or frail, or they just aren't quite sure, they need to get medical evidence of that person's capacity, which often involves sending a testator off to the GP or to a geriatrician to be assessed, and maybe even getting the GP to be a witness to the will. Very sadly, the judge who set out the Golden Rule in that case was still very good socially in his old age. He had a good front, and his own will writer didn't follow the Golden Rule, and his will was challenged this year. And it was actually held to be valid, but you wonder whether the trial could have been prevented had the Golden Rule been followed. I suppose the other thing that a will writer would ideally have done is to take really good notes on capacity, because the opinion of an experienced solicitor is actually given a fair amount of weight. There's a Court of Appeal case called Burgess and Hawes that said that the court shouldn't be too ready to overturn a will for lack of capacity if it's been drafted by an experienced lawyer who really considered whether the testator had capacity and concluded that he did. It's also obviously sensible for the will writer to see the testator alone rather than always seeing them with a person who might later be accused of exerting undue influence. And then I think in a practical way, the people who tend to bring claims against an estate are people who are often quite shocked by a will or its contents, or there's been a last minute change to a will. So if a testator has prepared their children for what their will is going to say, or maybe has written a letter explaining why they've done what they've done, it might be wishful thinking, it might not make a difference, but it's worth a try. I think that's probably all we have time for, given the talk was meant to be half an hour. If you still do have a question, you can contact me through the clerks. Their details are on the website, along with all the details of our previous and upcoming webinars. And thank you for coming. Have a good Friday, everyone.